The Narendra Modi government on Thursday promised the Supreme Court that it will not make new appointments to the Central Waqf Council or state Waqf boards in terms of the controversial Waqf Amendment Act of 2025. Another assurance given was that the legal status of Waqf properties, including waqf-by-user that have been registered or declared through a Gazette notification, would not be altered for the time being in the revenue records. With this statement, Solicitor General Tushar Mehta averted a possible stay order from the top court, which had on Wednesday indicated that it would defer the operation of three key sections of the 2025 law. A three-judges bench led by Chief Justice of India, Sanjeev Khanna, had voiced its view while hearing a batch of petitions challenging the constitutional validity of the Waqf Amendment Act 2025. The Waqf law governs management of Waqf properties. The amended law alters the 1995 legislation that held the ground until the 2025 Act got notified on 5th of April. While some provisions have been deleted, new ones have been added, which the Modi government has argued makes the law more inclusive. The bench had serious reservations over four sections, that are Sections 2, 3C, 9 and 14. Section 2 in its new avatar says that the Waqf law will not apply to those public trusts that were established for a purpose similar to that of a Waqf. This would be notwithstanding any court order or a decree. The court did not approve of this section because, in its view, it attempts to override judicial orders. The court had also raised doubts over Section 3C, which empowers a collector to determine a dispute that arises over a government land declared as Waqf. Though the entire section has been questioned for making the collector a judge in his own case, considering he is a government officer, the court was keen to stay only the first subsection of this provision because, according to it, this subsection threatens to disturb the existing status of waqf-by-use properties. In the court's opinion, to alter the character of properties that have been waqf-by-use for decades will have serious consequences. The next two sections, Section 9 and 14, deal with the constitution of the Waqf Council at the central level and the board at the state. Both the bodies are meant to advise the centre and states respectively over management of Waqf properties. Going by the new law, there will be more non-Muslims in the council as well as the Waqf boards. This has come under objection because, according to Muslim bodies, only Muslims can administer the management of Waqf. Despite expressing its concern, the court on Wednesday did not stay the provisions and, on Solicitor General Mehta's request, had adjourned the hearing to Thursday. So, on Thursday, Mehta at the outset urged the bench not to stay a parliamentary legislation directly or indirectly based on some prima facie or tentative reading of some sections. He sought a week's time to file his submissions on why no stay should be granted. But the bench remained firm and told Mehta that it was neither giving a final judgment in the case nor was staying the entire act, considering there are some good provisions in it. But the bench reiterated that it was concerned about drastic changes that could potentially alter the ground situation. This prompted Mehta to give the undertaking, following which the bench agreed to fix 5th May for a further hearing on the issue of an interim stay. As per the promise made by the centre, Sections 9 and 14 would virtually be kept in abeyance for the time being. This means that the central government cannot for now constitute a new central council to administer Waqf properties. And as far as states are concerned, the existing boards will continue to operate. And in case their term ends before the next hearing, the state would have to appoint members as per the old law that allowed only Muslims to be part of the body. Mehta's assurance also protects the legal status of registered and notified waqf-by-use properties. Since there is ambiguity in the law which does not explicitly shield such properties, the promise comes as an interim breather for them. However, the court is yet to take a definite view on whether the contentious provisions should be stayed or not until the case is finally decided. Till then, the centre's stand has brought some respite to the Muslim side that wants revival of the old regime to administer Waqf properties.